RSL has mentioned you have to leave because of a previous interest. From what I understand, that was in the Act as a pecuniary interest initially, and then people had to leave. But as you were a volunteer at the RSL and not paid, I'm just wondering where that still is part of the situation, because I'm sure nearly every councillor has been involved in lots of volunteer organisations, and they don't seem to leave when these things are mentioned. And I'm just wondering what the statute of limitations are in regard to the time that you have to wait before you can sit through any discussion on the RSL.
We have had legal advice on it.
Yeah. Thanks, David, for the question, and I'll keep my response fairly general because I'm not a lawyer and I don't want to pretend I'm providing advice to people when I shouldn't be. My comment would be that the conflict of interest provisions in the Local Government Act today are far broader and far more complex than the old pecuniary interest provisions used to be. The old pecuniary of interest provisions were really about, would you anticipate some sort of financial gain from a particular thing? The conflict provisions now contemplate much broader issues than financial gain. They contemplate the improvement of situations for relatives. They contemplate your employment. They contemplate whether you might have a conflict of duty because you're on one board and another board, the council's considering a matter that is considering this other board that you sit on. In the Mayor's case, I think the primary issue is that formerly an executive member of that group was involved in the early planning of this project, so has some ongoing obligation to declare an interest in it as a former member of the executive and part of the group that planned this development. I'm not sure that there's any actual time limit specified in the Act on how long the Mayor might declare an interest on this, but essentially it's one of those situations around the conflict of duty where a former member of one board doing a development now sitting on another board or organisation, the council considering that development. So the net is cast pretty wide now in terms of what potential conflicts might look like, much wider than just is there any personal financial benefit from it.
So you're suggesting if there's no limit on the time, then it doesn't make any difference because the decision's been made. Is that correct?
Well, I think we're getting into territory where you're kind of asking me to give advice now that's better given by lawyers, I think. But essentially the challenge for each individual councillor is to make their own decision about whether whatever the matter is in front of council, whether that presents some sort of a conflict for them in making their decision. So there may well be future matters that come up in relation to the RSL that wouldn't give rise to a conflict, and presumably once the council's formally considered the granting or otherwise of planning approval, future matters with the RSL may well be different. But kind of each individual councillor has to weigh those issues up themselves and make a decision themselves about whether they feel they're at all conflicted in being involved in those decisions.
Well, thank you very much.
Other questions? Mr. Nevin?
Gary Nevin, Bob Nawara. The reception of petitions, can anyone tell me why the petitions are confidential?
The only reason they're confidential is because they contain individuals' names, often addresses, so personal information. So it's a matter of privacy. They're not